What can I do here? I have joint equal custody of my children awarded to me with my ex, but technically I have them in my custody more often than my ex does. The mother makes the same amount of money, if not more, than I do. Now, this is a good question and a question that comes up often. I will answer your question as it would apply to the law of Utah, which is the jurisdiction where I practice divorce and family law. In many jurisdictions, who pays child support and what the amount of child support paid is based upon both, 1, the number of overnights the children spend with each parent, and 2, the respective incomes of each parent. Typically, this means that if the children spend more overnights with one parent than the other, then the parent with fewer overnights will likely end up paying child support to the other parent. This is why, aside from the fact that parents often want to spend as much time as possible with their children, the child custody and parent time award can often be such a highly contentious issue. Some people believe that if the parents are awarded joint equal physical custody of their children, meaning the children spend equal amounts of time with each parent throughout the year, then they think that means neither parent pays child support to the other. While it is possible for neither parent to pay child support to the other, where the parents exercise joint equal physical custody of their children, it is not always the case. Why? Because, as I stated earlier, child support is based upon not only the number of overnights the children spend with each parent, but also upon the parents' respective incomes. If dad makes 2 or 3 times as much money as mom does, the law in Utah provides that dad will still end up paying mom some child support, even if mom and dad exercise joint equal physical custody of their children. The reasoning behind this policy is that the children's lifestyle needs to be maintained at both parents' homes, and if one parent's income is substantially less than the other parent's, then that parent won't be able to provide the same kind of lifestyle to the children as the more affluent parent can. You may disagree with this reasoning, but that's how it goes. And so this is why more affluent parents will pay some child support to the less affluent parent, even if the parents were awarded joint equal physical custody. Bear in mind, however, that the more overnights the more affluent parent has with the children, the less child support that parent will pay. By way of a quick example, a parent who has 90 overnights annually with the children will pay substantially more child support than if he or she has the children in his or her custody and care 182.5 overnights annually. 182.5 is half of 365. And this makes sense. The more overnights a parent has with the children, the fewer overnights the children are spending with the other parent, resulting in the other parent spending less money housing and feeding the children. So what happens if the parents are awarded joint equal physical custody, but then one of the parents foists the children on the other co-parent, such that this parent winds up caring for the children more than half of the year? Now, most loving parents will not resent taking care of their children, but they may be upset about the fact that the child support award does not reflect the de facto child custody arrangement, i.e., I spend more time with the kids than you do. If and when one of the parents who is awarded joint equal physical custody is enjoying the lower child support obligation benefits of joint equal custody without actually exercising joint equal physical custody, that is unfair because the parent who is exercising more physical custody and providing more physical care for the children is, under Utah law, deserving of child support. So what can a parent in this position do? The way the law is designed, the parent who has had extra custody of the children foisted upon him or her by the parent who is unable or unwilling to exercise joint equal physical custody can petition the court to modify the child custody and child support awards to reflect these changed circumstances. The petitioning parent can ask the court, 1, to modify the child custody awards so that it reflects the actual amount of time the children are spending with each parent, resulting in the non-compliant parent's loss of the joint equal custody award, and 2, to modify the child support award so that it awards the primary custodial parent the amount of child support to which that parent is entitled based upon the number of overnights the children spend with each parent. I chose my words carefully here. Note that I stated that this is the way the law is designed to work. This isn't always the way the law functions, however. Far too often, when a parent who was awarded joint equal physical custody stops exercising joint equal physical custody but still insists that the child support obligation remain based on the joint equal physical custody award, and then if the other parent petitions for a modification of the child custody and child support awards because of that, what happens is this quite often. As soon as the non-compliant parent receives notice of a request by the other parent for a modification of child custody and child support awards, the non-compliant parent immediately becomes compliant and immediately and faithfully resumes the exercise of joint equal physical custody. Thereafter, by the time the case gets to trial, which is usually about a year to a year and a half after the petition was filed, the non-compliant parent's argument is one or both of the following. See, I'm not non-compliant. Yes, I can see there was a brief period where I was not compliant, but I was never as non-compliant as the other parent is falsely claiming. Besides, I've repented, and now everything's back on track. Clearly, there is no reason to modify the child custody and support awards. And these arguments work more often than not. How dare you accuse me of being non-compliant, is one argument. Allegations that I have not been exercising joint equal physical custody are lies! My children are my first priority and I treasure every moment I spend with them. I would never fail to exercise joint equal custody. If ever I have not exercised my joint equal custody time with our children, it is because the other parent is withholding the children from me. Now, before I go any further, please understand that there are plenty of joint equal custodial parents who, being very unhappy with joint equal physical custody because they wanted sole custody of the children in the first place, they will try to sabotage the joint equal physical custody award by lying and claiming that the other parent is non-compliant. So just because a parent who is responding to a petition to modify custody and child support denies these allegations against him or her, does not mean that such a parent is lying. Now, in my experience, Utah courts are reluctant to modify joint equal custody awards unless, by the time you get to trial, the accused parent is clearly still not exercising joint equal physical custody, or at least has been proven not to have exercised joint equal physical custody consistently. Bottom line, if you and your ex were awarded joint equal physical custody of your children, but your ex is failing and refusing to exercise joint equal physical custody, a petition to modify the custody and child support awards will not succeed unless you have overwhelming amounts of proof that 1. Your ex is not exercising joint equal physical custody as of the date your petition to modify is filed, and 2. Your ex has consistently not been exercising joint equal physical custody for a substantial period of time, at least 6 months in my opinion. If you try to modify the petition to modify custody after 3 or 4 months, that may be deemed too short a period of time to establish a period of non-compliance. And 3, you can prove that you are not preventing your ex from exercising joint equal physical custody. Because if your ex is failing and refusing to exercise joint physical custody, the only defense he or she may have to make or to have available to him at that point is to falsely accuse you of withholding joint equal custody from him or her, so be prepared to prove that this is not the case. Make sure you have overwhelming evidence in your defense showing that you are not standing in the way of the exercise of joint equal physical custody and are in fact doing everything you reasonably can to encourage and foster the exercise of joint equal physical custody by your ex.